Hi, welcome everyone to our webinar on legal essentials for product manufacturers. My name is Caroline and I'm a lawyer in LegalVision's regulatory team. I'm joined today by my colleague Rebecca Wood, who is a practice group leader in our regulatory team.
Thanks, Caroline. Look, first we would just like to get started this morning with an acknowledgement of country. LegalVision acknowledges and pays respect to past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Before we get into the webinar, let's just deal with a couple of housekeeping issues. Firstly, you're going to be emailed a copy of this webinar recording, so don't feel like you need to take furious notes. You can submit your questions that we can address in our question and answer session of the webinar into the chat box at any time. And finally, let us know what you think of this webinar by completing the survey at its conclusion. So today we're going to be discussing a number of issues in relation to product safety. Firstly, how product safely is regulated, what are mandatory safety standards. We're going to be discussing voluntary safety standards, product recall, and we're going to just do an overview of liability issues generally that arise in the context of manufacturing and supplying products. As I mentioned, there is a chat box, and at the end of the webinar, we're going to be answering some of your questions. So it's your opportunity to ask us some things that are concerning you and your business. So please submit these throughout the webinar using the chat functions, and we'll address them in our question and answer portion of the webinar. Finally, stick around as we've got a special offer for our attendees, so you can learn more about that a little bit later. Okay, so for now, let's just get started. We'll be discussing the regulation of product safety in Australia. A consumer has a right to expect that products that they purchase will work properly and that by using them, they're not going to get injured or ill. Businesses, on the other hand, have an obligation to ensure that the products that they sell meet acceptable levels of safety. So depending on what you're manufacturing, there are various laws in place that may require your goods to meet certain standards or that will regulate the trade of your goods. There are particular government agencies that monitor and regulate the safety of specific types of products. And we're going to touch on these more specific pieces of regulation towards the end of this webinar. But in general terms, and in terms of general consumer products, the Australian Competition and Consumer Commission, or the ACCC as it's more commonly known, and other state-specific consumer protection agencies, for example, Fair Trading in New South Wales, monitor, promote and oversee safety of products. The focus of today's webinar is going to be the Australian Consumer Law, which provides a national framework for product safety laws. The Australian Consumer Law empowers the ACCC to regulate safety standards for consumer goods and products. And it can do so by issuing safety warnings, banning certain products either on an interim or permanent basis, adopting and enforcing mandatory safety standards, and issuing compulsory recall notices. The Australian Consumer Law also outlines obligations for suppliers of consumer goods and related services. This includes rules about what businesses must do when a minister bans a product, issues a compulsory recall notice or implements a safety standard, how and when a business should implement a voluntary recall of a consumer product, and when a business should report or action certain safety issues with being overseen by the ACCC. It's important to know that the potential penalties that can be imposed when a business sells an unsafe product can be potentially catastrophic to a small business. Accordingly, it's vital that all businesses understand their obligations and risk exposure in order to manage them effectively.
Thanks, Rebecca. So now we'll discuss the Australian Consumer Law product safety provisions. So the Australian Consumer Law applies primarily to consumer goods and product-related services, Both these terms are defined under the consumer law. Consumer goods are those that are intended to be used or of a certain kind that are likely to be used for personal, domestic or household consumption. Product-related services are services relating to the installation, maintenance, repair, cleaning, assembly or delivery of those consumer goods. These definitions are relatively broad and cover a lot of different types of products, but the focus is that they are for household consumption, typically by a consumer. Any business who supplies consumer goods or product-related services is responsible for complying with the Australian Consumer Law product safety requirements. This means that all businesses in the supply chain, so that'll include manufacturers, wholesalers, hirers, and retailers, anyone who delivers a product or sells a product down to the consumer, must keep up to date with the law and comply with the applicable product standards or any product bans. For example, if you are selling a product manufactured overseas to a consumer in Australia, you still have obligations to ensure that that product is safe to use, even though you didn't make it. This is important to consider if you are importing and selling products that were not manufactured in Australia. Even if you did make the product, as we've discussed, even if you didn't make the product, you still need to ensure that you meet the safety standards under the Australian Consumer Law. Rebecca will now discuss what the mandatory safety standards are.
Great, thanks, Caroline. And an important note to be aware of, we get a lot of clients who are caught out by the fact that they actually are responsible for making sure that the products that they sell are safe. And it's not good enough in some circumstances just to rely on what a manufacturer has said or done. So in terms of the mandatory safety standards, as Caroline said, it's important for everyone to understand them and to make sure that any product that they sell complies. So the Australian Consumer Law provides for making of these mandatory standards, and what they do is they outline the minimum requirements a product must meet before they are supplied to a consumer. A mandatory standard will set out the way that the good should be made, what it contains, how it's designed, what safety or product tests it needs to pass, and whether or not any warnings, instructions, or specific labelling is required to accompany the goods. It's an offence to supply consumer goods or product-related services that do not comply with mandatory standards. The Product Safety Australia website is a great resource and lists all the current mandatory standards and product safety information. It's a service that's run by the ACCC. Currently, there are 41 mandatory standards in place that contain specific requirements on a number of products, including, for example, children's clothes, toys, infant and nursery products, sporting gear, cosmetics, and so forth. So if you operate a business that supplies a product that's regulated by a mandatory standard, it's very important that you're aware of the safety obligations under the standard and make sure the products that you sell are compliant. In addition to mandatory standards, you might also need to consider information standards. Information standards provide rules regarding product design and composition. Mandatory standards set out certain information that needs to be provided about a particular product. So from our experience, the most commonly used information standards may cover, say, ingredient labelling for cosmetics, or labelling for tobacco products, or care labelling for clothing and textiles. Caroline's now just going to talk about who's required to comply with a mandatory standard.
Yeah, so as we've sort of briefly touched on, mandatory standards on specific products apply to anyone in the business of supplying a product that falls into one of these categories. But basically, the mandatory standards will apply to manufacturers, importers, distributors, retailers, hirers, anyone providing the product to the end user consumer. All of these types of businesses are considered suppliers under the Australian Consumer Law, so they're all captured by that legal definition. It is a supplier's responsibility to ensure that consumer goods comply with the relevant mandatory standards. And as a matter of best practice, what we suggest is that suppliers obtain a copy of any applicable mandatory standards for the products they're selling and any additional documents that the mandatory standards refer to. These might include additional Australian specific standards that aren't listed with the ACCC. The standards, it's worth noting that the standards are not always built into the legislation and typically need to be purchased from third parties like SAI Global or Standards Australia. Suppliers should also seek advice and consider whether their products will need to undergo any product testing before sale. Product testing is not only part of the mandatory standards, but will help assure suppliers that they are supplying safe goods. To ensure your products comply with the safety laws and mandatory standards, you can conduct your own testing using suitable in-house expertise and facilities. For example, you can engage an engineer or compliance officer in your field. You could commission an external certification agency to assess products and provide written certification of compliance with the safety standards. This enables you to use certification labelling on your products if they are certified and pass that testing. You can commission reliable, independent and preferably accredited labs to test products and issue you with testing reports. You can ask your suppliers for written evidence of safety compliance through third-party product certification or product testing before agreeing to sell those products where you're working with like an external manufacturer. Ideally, you should obtain copies of these test reports, preferably from accredited test bodies or laboratories in advance. It's worth noting that where there are 2 or more sets of product standards that might apply, some mandatory standards will allow suppliers to choose which to comply with. To make this decision, you'll need to have an understanding of all the standards that might apply to really determine which is best for you to follow and which is best for the business. Additional rules may apply if consumer goods are being intended for export and to be sent overseas. So now we'll briefly discuss the penalties for non-compliance. Ultimately, it is an offence for failure to comply with a mandatory safety standard. Non-compliance could result in a hefty fine from the ACCC of up to $220,000 for an individual or $1.1 million for a company. Civil penalties can also be imposed on individuals or company directors depending on the level of non-compliance and the risks. Rebecca is now going to discuss the voluntary standards and how they work.
Thanks, Caroline. So voluntary standards are different from mandatory standards, I guess. As the name suggests, they're not mandatory and they're voluntary. So that means that they're not, you don't need to comply with them, but perhaps best practices that you should. So voluntary standards or private standards are published documents that will set out the specifications and procedures that are designed to ensure that the products that you manufacture or sell are safe, reliable, and perform consistently. They may address a range of issues that are not just safety related, but essentially that these documents would represent what we would consider best practice in terms of product manufacture. Voluntary standards are developed by non-government bodies such as Standards Australia and the ISO. And these standards you can search for, anyone can search for them and purchase them online. A voluntary standard often will exist because experts or government bodies have identified, or non-government bodies, sorry, have identified that there is a particular need to address a safety issue. In some circumstances, the federal government or the ACCC may decide to adopt part or all of a voluntary standard and incorporate it into a mandatory standard. So it is possible that voluntary standards could become the future mandatory standards. So it's important to perhaps be complying so you're ahead of the game. It is legal to supply products that don't meet the voluntary standards. However, you may be required to follow specific voluntary standards if you want particular accreditations to your products. Or perhaps if you want to join an industry body or group, it may be necessary to ensure that your products meet a certain level, and that may be a voluntary standard. While voluntary standards are not generally mandatory, manufacturers and suppliers should consider the guidance that are contained in the voluntary standards, as they essentially represent the considered judgment of other manufacturers, designers, and safety expertise. So essentially, it would be meeting the market in terms of what would be considered a safe product. If a company manufactures or sells a product that injures a person, non-compliance with the voluntary standard might be a factor that might be considered as to whether or not a supplier has departed from its standard duty of care in ensuring that a product that was supplied was safe. So generally, we would recommend absolutely comply with all mandatory statements, mandatory standards, and a matter of best practice, and to be consistent with your colleagues at market is to comply with voluntary standards as well. So what we're going to talk about now is identifying safety risks. So when a supplier becomes aware of a possible safety hazard associated with one of their products, what we would recommend that they do is immediately investigate, find the cause of the safety issue, and consider how it can be managed or corrected. As part of this investigation process, a supplier may need to decide whether or not the product could be repaired, modified, or recalled if necessary. The most appropriate action that you would need to take can depend on a number of factors, including the nature of the risk, the distribution of the product, and its expected life cycle of the product. So, for example, is this a product that's going to be sitting in a consumer's home for a long period of time, or is it something that's you're going to use once and kind of throw it away, for example? If the supplier becomes aware that a person has suffered a serious injury, illness, or death as a result of using their product, either in Australia or overseas, there's an obligation in the legislation to notify the Minister or the ACCC within 48 hours, and failure to do so is considered an offence. Suppliers should also ensure that the products that they are selling are not subject to a ban that's imposed by the ACCC. So the ACCC can impose an interim 60-day ban or a permanent ban. And failing to comply with the ban is an offence. So it's always important to be aware of bans and news updates coming from the ACCC. And you'll be able to get this information from Product Safety website. So if a recall is necessary, Caroline's going to step out the key things that you need to think about.
So when we're thinking about product safety recalls, when a safety problem is identified in a product, the product needs to be withdrawn or recalled. There are two types of recalls that occur, and they occur in different ways. Firstly, a supplier can voluntarily initiate a recall of a product. This will generally be if the supplier is concerned about the risk a product poses with respect to injury, or whether the product fails to comply with a mandatory or voluntary standard. The second type of recall is a mandatory recall, which is typically initiated by the ACCC or the Minister, usually where they have concerns about the product safety. If this second type of recall occurs, a recall notice will be published and circulated by the ACCC, and after this occurs, it's an offence to continue to sell that particular product. In Australia, most recalls are initiated by the supplier, and they are voluntary. Safety issues that are commonly identified by supplier, I guess, after the product is out in the market are, before the product testing, where the product testing is undertaken by the supplier, or as a result of the supplier investigating complaints and issues raised by their customers. So safety issues may also be identified by industry bodies or the ACCC, where a consumer makes a complaint to the ACCC directly, or a state-based body like Fair Trading. And then the supplier, has to consider whether it makes commercial sense or legal sense to recall the product depending on the risks. A supplier must recall products when they realise that the consumer goods may injure someone, where they do not comply with a safety standard, or where they're subject to an interim or permanent ban, as Beck mentioned. In some cases, the risk analysis about whether to conduct a recall may indicate, or the safety risk analysis may indicate that it's not necessary to retrieve the products from the consumer. However, in order to mitigate any safety risk, some other action by the supplier may be required. Now we'll discuss the differences between voluntary and mandatory recalls in further detail. So, what is a voluntary recall? As we've mentioned, a voluntary recall is where the supplier chooses to recall the goods where there are safety or even quality concerns. Suppliers should recall consumer goods that they have supplied if they realise the goods are likely to injure someone now or in the future, or if the goods, as we've mentioned, don't comply with safety standards or are subject to one of the bans. The supplier has the ultimate responsibility for implementing that recall. Recall should be implemented in accordance with the supplier's pre-planned recall policy and after consultation with the ACCC. In order for the ACCC to be sure that a voluntary recall will be effective and meet its objectives, suppliers will need to undertake the following actions. So that is notifying, the various, or the ACCC, in addition to other regulators of the recall, and providing details as to what other entities or businesses in the supply chain will be affected by the recall and those who have already been notified. Preparing and submitting a recall strategy to the regulators, retrieving the affected product from consumers and from other businesses within the supply chain, and submitting regular progress reports and updates to the regulators as required. So these points will typically all be addressed in a supplier's recall plan. It is important to note that where a voluntary recall is undertaken, a supplier must give the Commonwealth Minister a written notice by completing the Submit Recall Notification form within 48 hours of initiating the recall. These sorts of notices can be accessed at the Safety Recalls Australia website. A supplier must also give a notice about the recall to anyone they have supplied the goods to outside of Australia as soon as practicable. The supplier will additionally need to give a copy of that notice to the Commonwealth Minister within 10 days of issue. Conducting a voluntary recall can be costly and time-consuming. Depending on the product issue or your safety concerns, you may want to consider seeking legal advice before implementing a recall and to ensure that you meet those deadlines. Rebecca is now going to discuss mandatory recalls.
Great, thanks, Caroline. Look, so as Caroline mentioned, typically recalls in Australia are voluntary, and a mandatory recall will only be used in specific circumstances, and essentially when, for example, an interim or permanent ban has been issued, then a mandatory recall will be notice will be issued, or where the ACCC or a regulator considers that the supplier has simply just not taken satisfactory action to prevent goods from causing injury to a person. So look, once that mandatory recall notice is issued, the supplier must act quickly. It must recall the goods, inform the public as to the nature of the defect, or alert the public to any specific use or misuse of the product that would be considered dangerous or likely to cause harm. So what that means is that if the product itself is not inherently dangerous, but using it in a particular way is dangerous, that could be the purpose of the recall and the information that needs to be given to the public. A supplier must also inform the consumers on how they can dispose or get rid of the unsafe product if they're not planning on physically recalling the product itself. So the mandatory recall notice will advise a supplier what action must be taken and the time frame in which that action needs to be taken. And it essentially will require a supplier to either replace the goods, repair the goods, if possible, or refund the purchase price. Ultimately, a supplier will bear the cost of repairing, replacing, or refunding the cost of a consumer goods, including any necessary transportation costs if they have to go and physically pick the products up. However, if the product has been in the market for over 12 months or in the hands of a consumer for over 12 months, the supplier can reduce the amount of a refund that they need to give. So, I guess that accounts for depreciation of value of the product. Generally speaking, the ACCC and safety regulators will work with suppliers. It's more a collaborative process that they want to undertake, and to ensure that the first step is ensuring that a business can actually implement a voluntary recall. However, ultimately the regulators have the public's best interest in safety consumer as their critical focus. So if they consider that the supplier is not addressing the safety issues appropriately, or it looks like they're not going to be able to conduct the voluntary recall successfully, it's at that point that essentially a regulator will step in and issue the mandatory recall notice. So we've talked about product safety standards, we've talked about recalls. We're going to just talk about product liability more generally. So in addition to the obligations and penalties that can be imposed by a regulator for failing to meet safety standards, it's important to be aware that your business could also be exposed to civil claims that could arise from product safety issues. Consumers who suffer loss and damage because of safety defects in a supplier or a manufacturer's goods can, well, firstly make complaint to the regulator, for example, the ACCC, which will lead to some of the steps that we've discussed already, or they can take that manufacturer to court. And typically these types of claims would arise from a breach of a consumer guarantee, a breach of contract, or a claim arising in negligence. The Australian consumer law provides for a number of consumer guarantees that suppliers need to comply with, and these include that products and services will be provided with acceptable care and skill or technical knowledge, and taking all the necessary steps to avoid loss or damage, or that the products are fit for purpose and will give the results that the consumer and the business have agreed to. And finally, that they will be delivered within a reasonable time, and particularly when there is no agreed end date for the service. If there's a breach of a consumer guarantee, a consumer can seek to cancel the contract for services, or make a claim for compensation, for claiming their loss and damages that they've suffered. We note that it is not possible to contract out of your consumer guarantees. So unfortunately, there's not much something that you can cleverly incorporate into your contract services that can get around these particular claims that your customers can make. In terms of your contracts, Australian state and territory-based sale of goods legislation can impose implied contract terms in respect of product quality in the absence of any express contractual terms regarding product safety standards. So what that means is that even though there's not a specific contractual term that says that you're guaranteeing that your products will be safe, it will be implied into every contract that when a customer is purchasing contract or obtaining services, that they will be safe. And if they're not, they can make a breach of contract claim. Finally, it's a generally accepted position at law that manufacturers and suppliers owe a duty of care to customers to ensure that the products that they sell do not expose them to a risk of injury. Suppliers must ensure that they're not supplying defective goods and are obliged to provide product warnings. If a consumer injures themselves, then that supplier may be liable to compensate a consumer arising out of a negligence claim. So if a consumer takes a manufacturer to court, that court action can include a claim for financial losses and damages. Now that may be arising out of the breach of contract. So for example, what the contract was worth or what they've paid under the contract. They also might make a claim for an award of damages to compensate them for their injuries that they've sustained. And it also may be a claim for the expenses that they've incurred, so their medical expenses. Finally, it could also include a claim for their economic loss. So for example, if they injure themselves and they can't work anymore, you may see yourself facing a claim by someone who's making a loss of wages claim. So it may be that they can't work for 12 months, It may be that they can't work for 10 years. So the exposure can be significant depending on the nature of the injury. So while there might be a lot of legal defences to these claims, the best defence is being prepared. Minimise your exposure in the first place. And otherwise, ensure that you've got the right insurance to minimise your the financial impact that a claim may have on your business. So it's important to speak to your brokers to make sure that you've got the right insurance coverage. Caroline's finally just going to talk about some of the more specific sources of product safety regulation in Australia.
Yeah, so the bulk of this presentation has focused on the Australian consumer law product safety regime, but there are other perhaps more industry specific regulations that might apply depending on the type of product that you're selling. These are just a few that are worth noting and being aware of. So specifically, I guess, for pharmaceutical and medical devices, so that could be, medication, any sort of medical treatment product that, a doctor might use, those services are governed by the Therapeutic Goods Act, and that'll, set out the different types of testing and registration requirements in addition to these sort of obligations under the Australian consumer law. Medicines and other chemicals are also covered by the poison standard, so that's important to keep in mind. Agricultural and veterinary chemical products are captured under the Agricultural and Veterinary Chemicals Code. Food products are governed by the Australia and New Zealand Food Standard Code, and this will provide guidance on, food safety processes, manufacturing processes, packaging, and even labelling requirements, in addition to the various state rules. So there's also the Australian Dangerous Goods Code, which regulates, how dangerous goods are transported. If you think potentially about, the transportation of, flammable products like petrol and oil and gas distribution. Work health and safety laws often regulate industrial machinery and how those are used from a safety perspective. And finally, motor vehicles are regulated under the Motor Vehicle Standard Act, in addition to various state and territory legislation. And now Rebecca will discuss how to reduce your exposure in relation to product safety issues.
Great, thanks, Caroline. Look, now we're just going to basically sum up kind of the things that we've discussed today. So before you supply or manufacture goods, you need to ensure that they're safe. So some of the things that we would recommend that you do is, firstly, be aware of the mandatory or voluntary standards that might apply to your industry and ensure that your products comply. Get your products tested and certified. This will provide you with comfort knowing that your products are safe. Provide clear instructions for using the product safely. Provide warnings where possible against possible misuse, particularly where, for example, the risk of using a product incorrectly is foreseeable. So, for example, I'm thinking about knives and sharp objects where there's a clear risk that using that product incorrectly could cause a person injury. Develop a product recall plan, so think ahead. Have those procedures in place, so if you do need to conduct a voluntary recall, you can do so and engage with the regulator collaboratively. The last thing that you want is a mandatory recall to be implemented. Incorporate safety into the elements of your design and make sure that you've got a quality assurance program and that there's an ongoing monitoring of your products. Finally, when you get a safety concern brought to your attention, a customer complaint, don't dismiss it. Respond to it quickly, investigate it fully. Being proactive about managing product safety helps you minimize your exposure to consumer complaints and potentially financial claims, avoiding the cost of recalls or refunding replacing products. And finally, avoid damage to your reputation, which is key. If you think that you've got a product safety issue, contact us, get some legal advice. Or Product Safety Australia is a really great resource that can give you some preliminary advice. Remember that not addressing safety issues can not only result in harm to your customers and have potentially long life impacts, but it can damage your business financially and reputationally. Look, that comes to the end of our formal part of our webinar. Caroline, I'll just hand over to you for some final comments.
Yeah, so thanks for listening, everyone. You might find our publication the commercial contract checklist useful, which is available for download via the handout section of the webinar panel. We also have an upcoming event on cybersecurity breaches, your business legal responsibilities. That's next week on Thursday the week after, on Thursday the 25th of August. You can register via the link in the slides. And now we have some time to discuss some of your questions. We've already had a few submitted online. So the first one is, what software and/or cybersecurity standards need to be considered as part of product quality and safety? How does this apply to products that include artificial intelligence aspects? A big starting question, right, Rebecca?
Yep, straight into it.
Yeah.
Caroline, do you want to answer this, or do you want me to cover it?
Yeah, sure. So it's a really interesting question that we think, it would be worth exploring outside of the webinar. So some preliminary thoughts, though, on this particular issue are that, it's likely going to depend on the product itself and whether it's a consumer good as to whether it'll be captured by the mandatory standards we've been discussing today. For example, if the product is machinery, and in most cases, it potentially won't be a consumer good then. It'll be covered by, work and safety legislation or potentially voluntary standards. In general, software and cybersecurity issues, as we've mentioned, will be covered by voluntary standards typically. It's worth noting the Australian Cybersecurity Centre is a good starting point for, any of those standards and the different types of guidelines you can implement when doing software development.
Great. I think that's great. We've had another question about wanting to, I guess, understand a bit more about safety standards from the perspective of a supplier of beauty or cosmetic products. So thanks for submitting the question, and a great question to raise. Certainly we've seen the rise of a lot of our clients either setting up a side hustle business or a new business post-COVID, supplying beauty and products, cosmetic products, sometimes imported from overseas, sometimes manufactured locally. In Australia, the Consumer Goods Cosmetics Information Standard will apply in terms of labelling of cosmetic products. It's a mandatory standard, and so it's compulsory to identify the ingredients that might cause allergies or sensitivities, with the intention here to ensure that there's a reduced risk of a consumer using a product that's perhaps not appropriate for their skin. The standard will apply to products that are either manufactured in Australia or imported into Australia. So if you're importing, it's really important to know the composition of your products. So if your business is involved in importing or manufacturing cosmetic products, what you should be doing is checking with the Australian Inventory of Chemical Standards. And you might need to register your business with the Australian Industrial Chemicals Introduction Scheme. A couple of other comments that I'll just make broadly about cosmetics and beauty products is that certain claims about cosmetics are regulated. For example, if you can't sort of make certain health benefits claims, in that respect, some certain health benefits are regulated under the Therapeutic Goods Act. And there are also certain regulations about using the word natural. So we see a lot of clients trying to use the word natural in their product. So it's a natural ingredients or naturally derived product. The word of natural is actually quite regulated, so important to get some advice on whether or not you can make a claim along those lines. Finally, there's some guidance from the ACCC regarding cosmetic product labelling and product safety, and in general, your consumer guarantees will apply. Another question. Oh, sorry, you jump in, Caroline.
Yeah, I was just going to say, as you can see, even briefly touching on the cosmetics specific industry product, there's a lot to consider when it comes to product safety and the standards that apply. So this advice and getting it right in the first instance is always going to be quite important to make sure that you're not caught out. But we've had another question online. So the question is, for an online store selling goods on consignment, would this business be considered a distributor or a retailer? What are your initial thoughts, Rebecca?
Well, look, I mean, as a seller of products, I think you'd still want to make sure from a reputational point of view, firstly, that the products that you're selling are safe. But it is an interesting point. Caroline, any other thoughts?
Yeah, I think it sort of is going to depend on how you position yourself in the marketplace and what you hold yourself out to be to consumers. So, for example, if you are a marketplace, even though the goods are on consignment, it kind of becomes an issue. If you're just this middleman passing on the consumer good to down the chain, then there's perhaps more room to say that you're less likely to be a supplier. But I think, if you're the one with the relationship with the consumer, and depending on what's in your terms and conditions, whether it creates that consumer relationship, that there is a risk that you would be considered the supplier in that instance, even though you're only a consignment business. So that's probably one of the more grey areas, though, where you could sit between, a supplier versus not supplier. But either way, as Beck mentioned, the end user consumer, if there is an issue with the product, is likely going to come back to you for support in the first instance. So it's better to have all your ducks in a row before it gets to that point. Do you have any further thoughts, Rebecca?
Totally agree with that. I mean, we're definitely seeing a lot of novel and different business models arise, particularly on the online environment, and it can be quite tricky to see how they kind of fit into the sort of more traditional concepts of business that are regulated. So, yep, definitely worth probably getting some specific legal advice that would be tailored to your particular business model. Look, unfortunately, that's all we've got time for today. If you've got any other questions, look, we might be able to deal with them following the webinar, but thanks for your attention. Caroline's just going to talk a little bit more about our membership model. So Caroline, handing over to you.
Yeah, so we just wanted to go through some of the benefits of our membership service. This product is really useful to cover all of your business legal needs. It includes unlimited document drafting and review, unlimited legal advice consultations across a wide range of areas, and it has, a huge number of uses for your business to make sure that you're covered. So I know that, from a product liability perspective and a mandatory standards perspective, we often have consultations to discuss these issues at a high level. As you roll out different products into your, broader business model. You can request a complimentary consultation today to discuss how we can help you with your legal obligations for product manufacturing. To book a call, all you need to do is leave your contact details in the survey at the end of this webinar, or you can email reply@legalvision.com.au and mention today's webinar. This could be really useful to get through some of the questions we weren't able to get today, and point you in the right direction moving forward. That's all we have for now, but thanks so much for joining us.
Thank you.